They convicted Marcus Whitfield of second-degree murder in 1994. The jury took 4 hours. He got 22 years. Then a paralegal reviewing archived evidence requests found a sealed folder in a county storage unit in Columbus, Ohio, a toxicology report the prosecution never disclosed. The question isn't why it was sealed. The question is who signed the order to seal it. The case looked airtight. Whitfield's neighbor, Raymond Coles, was found dead in his kitchen on September 14, 1993. Blunt force trauma to the skull. Whitfield had argued with Coles the previous afternoon. 3 neighbors confirmed it. His fingerprints were on a wrench recovered from Coles's utility drawer. The medical examiner, Dr. Howard Sims, testified that death resulted from a single impact to the temporal bone, consistent with a wrench-type instrument. The state's theory, a dispute over a property line escalated. Whitfield entered the home, struck Coles once, and left. The wrench was the weapon. The argument was the motive. The jury agreed. The folder was labeled Coles R. Toxicology Supplemental. Date stamped October 2, 1993, 3 weeks before trial opened. Inside was a full blood panel analysis from Meridian Forensic Laboratory in Cincinnati, contracted by the Franklin County Coroner's Office. The analyst was Dr. Patricia Vaughn. Her findings ran 4 pages. On page 3, she noted a blood ethanol concentration of 0.31, more than 3 times the legal limit for driving. On page 4, something else. Elevated chlorpromazine levels, a sedative prescribed in 1993 almost exclusively for psychiatric patients. Dr. Vaughn had added a handwritten margin note. Subject may have been incapacitated prior to trauma. Recommend neuropathology consult. That consult never happened. The report never entered evidence. The folder went into storage. Here is the problem that creates for the conviction. The prosecution's entire theory required Raymond Coles to be physically functional, standing, capable of resisting force. The wrench mattered because it explained the single decisive blow, one strike to subdue a resisting adult male. Dr. Sims testified to exactly that, but Dr. Vaughn's report changes what that single blow means. A man with a 0.31 blood alcohol level and chlorpromazine in his system is not standing. He was barely conscious, possibly already on the floor. The force required to cause that injury to a prone, sedated body is dramatically different from the force required to subdue someone fighting back. And there is a harder question embedded in those numbers. Where did the chlorpromazine come from? Coles had no psychiatric prescriptions on file. His physician confirmed that at a post-conviction review in 2006. Nobody at trial ever asked. The folder had 2 signatures on the outside. Dr. Vaughn's initials on the chain of custody line, dated October 2, 1993. And an administrative stamp from the Franklin County Coroner's Office, dated October 9th, placing the document in what the office called supplemental archive, a designation for duplicate or redundant materials. Dr. Vaughn's report was neither. In 2006, a journalist from the Columbus Dispatch filed a records request for all supplemental archives in the Coles case. She received 3 documents. None were the toxicology report. The folder the paralegal found had never been formally logged. Case number, signatures, chain of custody form all present, and yet when the official record was searched, it did not exist. But the toxicology report wasn't even the strangest part. Behind Dr. Vaughn's analysis, the same report that flagged that 0.31 reading and the unidentified sedative was a routing slip. A standard form recording the transfer of materials between offices. Originating lab, receiving office, date, receiving clerk's signature. The clerk's name was Gerald Barr. Barr worked in the Franklin County Prosecutor's Office, not the coroner's office, not an evidence room, the prosecutor's office. The slip showed the report transferred from Meridian Forensic Laboratory directly to the prosecutor on October 4, 1993. Trial began October 24th. That is a 20-day window in which the lead prosecutor, who put Dr. Sims on the stand, who argued a standing victim struck down by a wrench, had in his possession a forensic report suggesting the victim was already incapacitated before any blow landed. Gerald Barr signed for it. The prosecutor was David Melling. Melling was appointed to the Franklin County Court of Common Pleas as a judge in 1997. What the conviction required was a specific sequence: argument, entry, assault, death. What the report introduced was a different sequence, one where Raymond Coles was already compromised before anyone arrived. Fingerprints on a wrench in a drawer do not place a man at a scene at a specific time. They place his hands on an object at some point. The fingerprints were never dated. The chlorpromazine was never sourced. The report was never disclosed. Whitfield served 15 years before a post-conviction review released him on procedural grounds, not exoneration. His conviction was not vacated. His record was not cleared. The state treated that distinction as the end of the matter. The routing slip is still in the folder. Gerald Barr died in 2011. David Melling retired from the bench in 2019. Nobody has explained how a sealed forensic report bypassed the coroner's office and landed in the prosecutor's files. Nobody has explained where the chlorpromazine came from. Nobody has been asked.